Clause 4 of the bill says that no company incorporated under this act shall have a nominee shareholder. It doesn't say what a nominee shareholder is. It's not a defined term in the Act, the Principal Act. Madam Speaker, the vast majority of companies in Jamaica are incorporated by persons in the office of the attorney or other firm that's incorporating them, signing the articles of incorporation. They do so as a nominee for the client, and that is subsequently rectified thereafter. I don't know how many companies are going to be immediately in breach of this. There's no provision for it to a period of time to fix it. And in fact, one has to question why it's even in here. What this act is primarily about, these reams of pages, are about disclosure of beneficial ownership of shares. So if you have to disclose beneficial ownership right up the chain, then why can't you have a nominee shareholder? Because the whole essence of a nominee shareholder is that the shares are held by A on behalf of B, and B is a beneficial owner. It is a question of commercial convenience that these arrangements be facilitated. It is going to be extremely inconvenient to require subscribers to be the persons who are beneficial owners when you're incorporating. The clients may be all over the world or all over Jamaica. So I don't understand why this is necessary. It doesn't seem to me to make sense to do it this way. In Clause 7, it talks about what the Register of Members, this is an amendment to Section 109 of the Principal Act, which deals with the Register of Members. And it talks about what particulars have to be included in the Register of Members, and it's a much more extensive thing than it used to be. I'm not seeing anything that excludes public companies from this provision. There's an exclusion of public companies from amendments to the Register of Members. If you amend the Register of Members, you have to notify the registrar, and you have to produce details as to the amendment to the register. And there's a provision, a new subsection 4, which says that that requirement of any change in the particulars of who is in the register as the owners of the shares does not apply in relation to membership of a public company. I can understand why. Public companies have thousands of shareholders typically, and they trade on an exchange. And trading takes place every day. It's not practical to comply with this regime in relation to public companies. But there's nothing in here that speaks to the register when it is initially set up. Only deals with changes to it. So I don't know how that will work. If you take a company public, you have an IPO like we've had with Wigton or Trans-Jamaican Highway. God knows how many shareholders subscribed for shares in Trans-Jamaican Highway when it went public. Are we going to have to comply with this in relation to the register for that? And indeed, where shares are held in the depository, the Jamaica Central Securities Depository, which the vast majority of them will be, because you have to be in the depository to trade the shares. How is that being addressed in here? I don't know. There were regulations that addressed that in the past. I'm not seeing those being amended. So I don't know how that will work. The minister said how important this bill is because it ensures sanctions for breach, but there are no sanctions for the breach of that provision. The Clause 4 inserts a new Section 23A into the Act, which is one very brief provision with it's not made an offense or anything. That says no company incorporated under this Act shall have a nominee shareholder. There are no consequences outlined for breaching that. So the implications of this are half-baked and are not clear.